Almost there. Bam. Hey, everybody. Welcome tonight. Running a little bit late, but we're here. I think I seem like I've been on every night this week, right? Okay, it's not been that bad, but we're going to bring it tonight. So let me give myself a thumbs up. Got to hit that like button because I know I'm going to like what we got to talk about today. Welcome, you guys, advocates for justice, paralegal service. We have the tools, you do the work, and we don't play around. So tonight, let's just get started. Tonight, we're going to do a couple of things tonight. One, we're going to review the jurisdictional challenge with an affidavit again, and we're going to keep. This time we're making a little bit of a change to make it. Actually, I don't really like to make things easier, but this is easier and going to be more effective. The change that we're going to make and the strategy for using the jurisdictional challenge with an affidavit. Now, when you talk to me about the jurisdictional challenge with an affidavit, you have to call it that, or we use the first letter of each name in the title. That'll work, but you have to make a differentiation between the jurisdiction document that's already in the package. And I'm going to make you do that if I'm talking to you, communicating with you, because if you're asking me about the wrong thing and I'm thinking you're talking about something thing over here and we got the things mixed up, we have a things thinking thing issue. Excuse me. Okay. We're going to have a problem. So to make sure that we're on the same page. And for me, I want to make sure you understand and that you are following the rules, the instructions, the directions, the coaching, or whatever, because it's important. It's important for you to follow those little things because they add up to the big things in the end. Hey, welcome, Free Church. And Austin, welcome, buddy. So tonight we're going to talk about that. We're going to review that, and we're going to talk about the new change. And we are also going to cover something new that I have been working on for a few years, and I think it's about to come to. It's about to gel. That's what we'll say. It's about to gel, and I need some guinea pigs for my new project that I've been working on for several years. We'll talk about that later too. I'm just going to let you guys think about that because that's going to be interesting. And if I've been working on for a long time, it's going to be hot. I may have to move to Mexico when we get done with this. And I'm just thinking out loud. I ain't going nowhere. They know it. They know where to find me. And they already tried to shut me down a couple of times, but I'm still here. And I got a line of mofos back there. Yeah, but I'm still here. So we're going to keep going because I'm still here. So let's just before we get started, I want to tell you guys to make sure that you click that like button. Click the like button, ring the bell so you get notification when class starts, and make sure you subscribe so you can be in the program. Because once we get a little few more things ironed out, people in the program are going to get a special deal. So people that took the time to subscribe and do all these things are going to get a special deal because I'm thinking those are the people that really want to get up in here and get some shit done. Okay. People sitting around waiting for other people to win and all of that aren't the ones that's waiting to get anything done. And people have no idea when the floodgates open up, it's going to be a lot of people getting shoved over the cliff because everybody's sitting on their ass thinking that the moratorium is stopping everything and I don't have to answer to nothing to get that shit from the bank, from the court. I'm just going to park it over here. Yeah. Well, newsflash, the moratorium didn't stop shit. All it did was slow down people actually getting kicked out of the house on the street. A lot of people don't know now that they already have a default judgment against them in the eviction court. the unlawful detainer. They have several shitty ass names that they call it, and that whole process is fraud too. And there's a way to fight that. And I have videos on in the eviction playlist that you can watch and educate yourself on that. But the problem is going to be that you're going to find yourself in default because the court process never stopped. And I had a person tell me, "Oh well, I didn't get you don't get shit. You need to figure me out." And they know that everybody's going to be pushed up against each other, and they ain't going to have time. The court ain't going to have time to figure out if you got something that you didn't get, or if you didn't get something you thought you were supposed to get because you. Okay, you see where I'm going with that? Okay, they are not going to give a shit, and I'll tell you that right now. So those people who wait around till the last minute, oh, I got time because the moratorium, you have no idea. And when that happens, the court's just going to be tick you up. I mean, hell, in eviction court, what, you get 15 minutes? You're a trial? Well, they say it's a trial, but there was no jury selections. So if you didn't get to have jury selections, then how are there going to be a trial? Oh, wait, there can be a trial with no jury selections. All you need is a judge. Uh-huh. You people that got evicted, you know exactly what I'm talking about. It ain't really funny, but we got to be stupid about it a little so we can figure out how to kick their ass, and that's what we're doing here. So the jurisdictional challenge with an affidavit. Now, this document is not like a motion to dismiss your case, okay? This document is a document to challenge the jurisdiction of the court. And when the document was originally structured, it was structured to be used with the lawsuit package. You would want to use the jurisdictional challenge with an affidavit to slow down the state court, jam them up, while you go ahead and get your stuff filed over here in federal court. And then you move everything from federal court with the removal motion, remove everything from state court over to federal court and connect it to your title dispute. Because here's the deal. What's going on in state court, the eviction process and all of that is immediate possession, and immediate possession cannot be determined until the title dispute's been settled. And that is the only way that I found, other than this other way we're going to talk about here in a few minutes, to stop the judge in state court from going through with the eviction and kicking your ass out on the street. And even if you bring the fire, you have to make sure that you got some kind of way to back it up, because judges don't give a shit. They already know that 95 or 98% of Americans can't afford attorneys. And if you do hire an attorney to help you in foreclosure court, that attorney automatically gets a cut of what they steal from your ass, in addition to what they take out of your bank account every freaking month for pretending to be helping you the whole time while they throwing your ass under the bus. Can I get an amen? So the motion, the document is not like a motion. And what you want to do is you want to file it to jam them up. But you got to understand what you're doing. You got to understand what you have. You have more power than you realize. And the judge is not supposed to answer to that. The document is supposed to be, the person that actually filed the lawsuit is the one that's supposed to prove jurisdiction, not the judge. So you can't file it and go sit down and wait for the judge to dismiss it. Because if you file it and they don't respond to it and you go sit down and you don't do anything, then the judge is going to think that you're stupid and is going to dismiss it because you're allowing him to. The way the thing should go is when you file it within 14 days or whatever amount of days they have to respond. If they don't respond, they should be getting defaulted. And then after they get defaulted, you should ask for summary judgment. And these things should be going on long before the judge has a chance to file anything. Now, if the judge, and this is going to be the change that we're going to add to this, so I want to put this in the beginning. If the judge interferes and dismisses your jurisdictional challenge with an affidavit, then sue the judge. You have a document in the package to do that if you got the lawsuit package. If you don't, actually, the best document to sue the judge with would be the new $75 package that we put together a few weeks ago, I don't know, a little while ago. And that's the document that we use in our judicial foreclosure that we make the judges terminate the case in. Now, that document, you're going after them, and this is what we do in this program. Okay, we don't go in this program we don't go into court like kissing their ass or asking them for shit. Okay, we don't ask them for shit. You're going to go in and you're going to attack them for fraud that caused a problem that you're facing right now. So what they're saying you did, you're going to attack them for the BS they did, the illegal shit, to put you in the position to allow them to catch you. Okay, you guys keeping up with me? Big difference. Okay. Now you understand why who the servicer was and all of that shit don't matter. Because we're not going to go on defending the lies that they said you did or didn't do. Where the hell's that going to get you? You already know that ain't getting you nowhere, or you wouldn't be looking at, you wouldn't have found me. Okay, so we're not going to be doing that. And we don't connect anything that we're doing with the bullshit that you was doing before. Most of you, okay, and I'm just going to go here. Most of you, when you were fighting, you did not have the number one person down as the right number one defendant. Most of you did not have the person who signed the document to start the foreclosure against your property listed on your paperwork, on your lawsuit, on your complaint, any place. And if you ain't figured it out by now, that person would be the attorney. The attorney is the one that's suing you, trying to steal your property. It's not the freaking lender. And if you don't understand that, you better start packing your shit. I'm just keeping it real. Because if you don't have the right person down on there, then they're going to just let you flop around in court, try to get tired of your ass and kick you to the curb for a failure to claim, for a failure to state a claim for relief. And you can redo it the whole time, but if you don't have the person on there that signed to sue you, then it's you. You see what I'm saying? So the judge has no legal say in anything until the attorney responds and until you reply. That's how that goes. The attorney responds and then you reply. That's how that goes. The judge doesn't get to dismiss everything before the attorneys have even responded, and the attorneys are in default. Yeah, yeah, you know what I'm saying. So the judge cannot answer on behalf of the attorneys. I've seen that happen a couple of times too. The good thing about this program is I get to see a lot of stuff that most people don't see because I'm working with so many people from all across the United States of America. So if the judge interferes, then we need to just step up and sue the judge and stop playing around. And this is the thing that one of the changes, the biggest change that we're making in our program. The document, the $75 document, goes after the judge for violation of Administrative Procedures Act of 1946, and it also goes after the judge for violation of Foreign Agent Act of 1938. So you don't have to wait until they take your property to attack the judge. And the beauty of this is that once you jam the judge up for being in violation of the Foreign Agent Registration Act of 1938, that's a federal law, and so is the Administrative Procedures Act. And the Administrative Procedures Act of 1946, if you win, would force them to, when I say them, I'm talking about the corporation that's trying to steal your property, which would be the court and the attorneys, the people that you got listed. It will force them to change their policies to be in line with the Constitution, and they can't do that and make any money. So that's the problem for them. I don't think people understand how powerful that document is they have, and a lot of people don't really spend the time reading it and understand it. But we're going to look at it right now, and I always talk about the 6 things. What are the 6 missing things? The one thing is that the statute that they're using for foreclosure is not a valid law because it doesn't have the 3 elements. That's the one thing. But the three missing thingies, okay, yeah, people don't know what those are. And if any of you know what one of those are, copy and paste it in the window. And we're going to pull that up here in a few minutes. So we are learning how to cut to the chase. And that's what we're doing now. We're learning how to cut to the chase. So that $75 lawsuit package against the judge allows you to sue the judge, okay, for the judge being in violation of the judgeship shit. The judgeship, okay. The judgeship stuff that they're supposed to be doing to be legal. Now, here's the thing. If you tell the judge up for violation of federal law and the judge is not, it hasn't filled out the foreign agent registration paperwork or none of that, then that's a problem. Because now all the judges shit is going to be called into question. So all those other decisions where he gave people's houses away. See, if you understand this, you figure you have more power. Most people take my shit. Okay, I'm going to go file it, and then we're going to. No. You need to understand it. Because if you don't know who you're going after and what you're setting yourself up for, when it's time for you to hit that home run, you'll be sitting down over there and the judge will be dismissing your shit because you're not getting done what you need to do to let them know that you're serious and you ain't playing. So we're going to review the jurisdiction challenge with an affidavit. We're just called the JDCWA to make it a little bit, that's the abbreviations, to make it a little bit easier, or the JA, the first and last. Anything different than what we're calling already, what we already had in the package, so that we can make sure that we're on the same page. So there's 6 missing things that's noted in the jurisdictional challenge with an affidavit. I just like to say the whole thing anyway, because I like to make other people do it. So, okay, sorry. Let me pull this up so we can take a look at it. I don't know if I'm going to be able to screen share. No, my recording went off because my area on Zoom is full. So, and that's what it was telling me when I was first opening up, and I didn't have time to mess with it to try and figure out how to make it short. So I didn't realize when my recording goes off, I cannot show. Yep. I cannot show the share screen, but that's all right. So what we're going to do is we're going to just improvise. So the jurisdictional challenge was an affidavit. If you got one, you can whip it out and pull it up on here. What we're going to talk about are the 6 missing things, and they start out on page 5. And on page 5, it starts out that you declare. Okay, let me make this a little bit smaller so that I can see it better. Okay, so you're declaring that you're competent and that you have personal knowledge of the facts herein. And it's funny because I had a lady tell me, well, I don't have personal knowledge. I said, well, hell, neither do they. So what the hell? Are you kidding me right now? At the end of the day, they're the ones that have the burden of proof, not you. Okay, so you can not worry about you don't have personal knowledge, or you can jam their ass up and make them freaking have to go sit down. So you ain't going to do it by being nice. Now, they can't prove that you don't have knowledge. Okay, they don't want to talk about this stuff, so they're not going to be worried about your knowledge. I guarantee you, when you understand these 6 things, This is the only thing that I would talk to them fools about in court or on the phone. I would call the attorney's office every day, asking them for these 6 things. You want them to know that you know and you understand these 6 things, and they're going to be a problem. Now, the reason these 6 things are a problem, because these are the 6 things that went wrong in the mortgage deal that threw you under the bus. And all 6 of these things should have been the opposite of what they are. So you're saying that in the original agreement, you agreed with the lender that these 6 things were in the contract. So this is a slick ass way of forcing them to have to bring the contract to the table to go forward, because they're not going to be able to dispute whether these things are in the contract or not. They don't have the damn contract. All they have is a copy, and that copy is not what you signed. The judge said, "Did you sign that? Is that your signature?" No, I did not sign that, and that's not my signature. If it was, Your Honor, it would be in blue ink. You know that. Any more questions? Yeah. So what you're saying is, I, John Doe, declare, this is number 4 on page 5. You're declaring there's an addition to the agreement with the following items that are not shown on the contract filed in this case. The intent of the agreement, and this is the first one, the intent of the agreement, the original party who funded the alleged loan as per the bookkeeping entries would be repaid the money. Now, for those you don't understand, your signature created the electronic credits that they're calling this a loan. They never made you a loan. They turned the promissory note into a security stamp paid to the order of on it. The bank president signed it, and they cashed it through the Federal Reserve for electronic credits. You could have done that yourself. Yeah. So they never made you a loan. What you're saying here is that you agreed with the lender that they would pay you back, because here's the deal. The bank, there is a federal law that prevents the bank from loaning the bank's money to people. The bank is not allowed to loan its depositors' money out to people. So where the hell do they get the money they loan? All the bank is legally supposed to be doing is making money off of the interest that they charge you. But there's some slick ass mofos, yeah? And now they've been making everybody pay for 30 years on shit that was created with their own signature. I know for the people who think I'm crazy, that's okay, because I done my stinking homework. So let's move on to the next one, B. So you're saying in the original contract, B is missing also. The bank or financial institution involved in the alleged loan will follow GAAP. GAAP, in case you don't know, is the bank's accounting principles. They're the federal laws that the banks are supposed to follow. Now, this is powerful because you and the federal and the institution agreed that they would follow the GAAP laws. Well, they're supposed to anyway, but they did not. That's the problem. So they can't answer that. We was going to. See, this is the power in this document that people don't understand. Okay, C, first off, the first thing that we said was the problem here was that the original contract was altered and stolen. I think I forgot to cover that. That's the first thing. And then you go into these 6 things. So we're going to go into the financial institution involved in the alleged loan will purchase the promissory note back from the borrower. So we're going to go with D. The borrower does not provide any money equivalent, credit, funds, capital, or thing of value as the bank or financial institution will use to give value to check or similar instruments. So what they're saying here is that The borrower didn't provide anything. They didn't provide any money, any equivalent, anything to give value to the instrument. So that means that the instrument, the value that was given to the instrument was given because your signature was on it. And in case you don't know, the instrument they're talking about is a promissory note or the mortgage note. Sometimes they monetize, they cash in both. So E, the borrower is to repay the loan in the same species of money or credit that the bank or the financial institution used to fund the gap, to fund the loan as per GAAP. So what you're saying here is that you agreed, this is one of the 6 things you agreed to, that you would be able to repay the loan in the same species of money or credit that the bank or the financial institution use. So that means you can write a promissory note to pay off the entire amount and be done with that shit. If you understand these 6 things, you will see the power in this document. Now, E, the original written agreement gives full disclosure of all the material facts. And you're signing this under the penalty of perjury, and you're declaring that the original contract will show that the bank agreed that you could repay using an IOU, a promissory note, payable in the same species of money or money is equivalent to credit. Yeah, yep. And you're signing your name on this. Now, if they want to say that this is not true, they're going to have to do it by counter affidavit. Oh, wait, they can't. They cannot respond by counter affidavit because their asses are lying. Bam. So I tell people right away, they're not going to respond. If they do respond, they're going to respond with some BS. They're not going to respond on the merits and nothing that you got on this document. And it goes on a little bit further. That the attorneys failed to provide the court with adequate assurance of due performance. The bank did not give you a deposit slip in violation of 12 U.S.C. A section 1813. Yeah, this document is very powerful, but people don't spend the time to understand it, to figure out how to use it. And let me tell you something. It's more about the facts than it is about the damn case law, because the case law is their shit anyway. Okay, if you can't get past the facts, you don't need no damn case law. I like to keep the shit simple. If you keep it simple, there's no room for arguing, because you guys know their program is structured for arguing. And when the arguing starts and ends, their buddy judge gets to help them. It's pretty simple with me. That's why we like to go in with shit they don't want to argue about, because we ain't trying to do the arguing. Arguing is not going to help anybody. So let me see here. Hey, James, I got a few more people up in here. Ken, welcome, buddy. So Nikki Wise, does the JA good only for homeowners and defendants? So Nikki, if you understand the document, you can use the document for what you need. So that's how I'm going to answer that question. The document is for what you have the creativity and the courage to use it for. And this is what I mean. That document, it's not about the stuff. People say, oh, I bet you spend a lot of time in law. I don't spend any time in a law library. I live on Google. Okay. I'm just there. I said it. I live on Google. I don't spend any time in a law library. You have to use the facts to help do what you need to get done. Now, the facts in that jurisdictional challenge with an affidavit can be put into a motion to dismiss something lickety freaking split because they can't respond to that shit. You can't respond to it. If it was me, if I own property they was going foreclosing on, I would answer. I don't use that word answer generally. I respond, but I would answer to their foreclosure complaint with my jurisdictional challenge with an affidavit. And if they can answer me by counter affidavit, their ass is done. Oh, wait. If the judge wants to jump in and help them, then I'll have the $75 document gem judge up. Nothing like gem the judge up with a $75 document. Now, the jurisdictional challenge with an affidavit comes with a motion to moot all of the documents filed in the case until jurisdiction has been proved on the record. You want to file that too on the same day. And then I'd wait a day or so and then file that motion against the judge, because I guarantee you the judge is in violation of the Florida Agent Registration Act, and I guarantee the judge in violation of the Administrative Procedures Act of 1946. So you can just, why screw around? Take charge. For $75, you can take charge. But I got people want to know how many wins and how many, is it for the defendant? Is it for this? Is it for that? Take the damn thing and stick it up their butt. Okay, that's what I'm telling you. Okay, don't worry about all of these other things, because at the end of the day, none of that shit you're worrying about is going to matter. At the end of the day, what's going to matter is if you are jamming the judge ass up. Because the way this goes, and you guys tell me if I'm wrong, the way this goes is most people sit back and worry about so many little things, and those little things aren't going to have anything to do with it. So, Nikki, you need to use it and figure out how to use it for what you need. That's what my program is about. Okay, it's not about, is it for this or that? You can take anything that I have and you can use it for what you need if you know what you need to do and how to do what you need. So that's how you do that. People have to remember, I'm not an attorney, so I'm not going to tell you. I'm going to tell you what I know, and that's what I know. If I told you this or that, you're going to get tripped up. You need to figure it out and do it yourself. I provide the tools, you do the work. That's how it goes. You can make anything be the plaintiff or be the defendant or whatever. And the stuff that I'm throwing on the table is for people to be the plaintiffs with, even if they're calling you the damn defendant, okay? So remember that. Hey, Quentin. So how do they allow third party to pay your taxes? Anybody can pay your taxes, Quentin. And, they and when they do, they got the eyeballs on your shit. So you can, and you know what? You know how they're able to do that? They're able to do that because they tricked you into registering your deed in their office. And once that deed was registered in their office, that allowed them to start charging you property tax, zone coding, and all of that shit that they do to make you crazy. And here's the thing. There's no law that mandates that you have to put your deed in their office. So you should be able to request to have your deed returned to you, right? And have your information removed out of their office. That information in their office, Quentin, is what allowed them to put the first illegal lien against your property. And if you don't know what that first illegal lien was, it was the mortgage lien. And I get into it with these fool-ass attorneys on Facebook all the time, trying to jump up in my business and tell me that I'm crazy, okay? And this is what I tell them. If several people own property and there was going to be a mortgage lien or any kind of lien put against that property, all of the owners would have to be present to sign, right? Yep. So the fact that the bank accepted your signature for the lien against the property proves that you own the property free and clear, or the bank would not have been able to accept your signature on the lien against your property. Could it be so simple? Yeah, they say, the patent is a good thing to do. I don't know a whole lot about it, but what I do know is that once you don't get your deed out of their office. So my eliminate property tax lawsuit package is really not about eliminating property taxes. I mean, it does, but it's disguised. Basically, what you're learning how to do is get control of the deed to your property. But if I told you, hey, I have this package to help you get control of the deed to your property, you wouldn't see any value in it, because you'd be saying, oh, I got my control of my shit already. It's over there in their office. Yeah. Here is a link to my eliminating property tax lawsuit package. So what I've done is put together the lawsuit that you would need to go after them for the illegal shit they're doing with the property tax. And it starts out with a notice of claim letter. And the notice of claim letter is kind of the lawsuit, but it's in a little bit different format, a little bit different. So it's in a letter. So but it's basically has the same thing that you're going to be bringing in a lawsuit, because I don't play around. We ain't trying to save shit for a trial and all of that stuff. I want to throw everything on the table now, flex a little muscle up in here, and stick it in their face, because that's how we do it. And I've got some really good reviews on the eliminate property tax lawsuit package. I think the main thing with that package is that when the attorneys get their ass kicked, they force you to sign a non-disclosure statement, that you ain't gonna disclose shit to big mouth assholes like me. And I'm all right with that, okay? Because I don't need disclosure. I mean, it's nice to have reviews, and it's nice for people to see that people are pleased with my work, but I don't spend a whole lot of time worrying about all of that stuff, because the people who got to ask me, okay, haven't done how many wins and all that shit, haven't done your homework, okay? Have not done your homework. At the end of the day, a win's going to depend on how much guts you have to stand in there and take the heat that they're going to be trying to give you to make your ass go sit down with my stuff. So as far as my stuff goes, I've done the homework, and I know my shit is sound. The problem is the freaking corruption. That's the damn problem. So, and we're figuring out ways to get around that too. Like now, instead of having to file the 26 documents and non-judicial foreclosure shit, as soon as the judge is involved, shit, you got something stick right in their face. Get that shit shut down. And now you can have the new judge, because you're going to recuse that judge. In the lawsuit package, you got the reconsideration package that has everything you need to recuse the judge, file a claim against the judge. Then you can file your $75. Yeah, you got all the stuff. You're going to spank them just right down good. So, yep. Thank you, Diesel, for We the People News. I spent a lot of time in putting together a property tax package. And to be honest with you, I spent quite a bit of time on it because it was so easy. It was so you start the gate. So what initiates this? Every state, every state has a real estate deed transfer statute. The laws mandate that your deed is supposed to be delivered to you. But I'm sure you didn't get your deed delivered to you, did you? I won't wait too long for an answer, because I think I know what it is. No. What they do is what they call their constructive delivery, and they register your property in their office. Now, it states in the Constitution not once but twice that private property is illegal to tax private property. So what they do is, once they register your property, they reclassify it to one of their commercial classifications, agricultural, industrial, or residential, and then they start taxing you. So that's how they do that. Oh, the other thing that I was going to talk about today is this new project that I'm working on. So I'm working on a new project. When I started working on what I'm doing now, my goal was to have one document stop the foreclosure and kick their ass. And I still had that goal, but other people's lives are at stake and their families and things. So we have to do some things a little bit different. I'm all right with that as long as we're still kicking their ass. But I still have that in the back of my mind, that one document. Okay, so you see where I'm going with that. So I'm done with that. I have another goal now. Yeah, I know. Mi amigos dígame yo tengo muy loco, okay? But that's all right because I am a little crazy. So my new goal is I want to put together a package that can stop the mortgage payments. I mean, I can't say stop the foreclosure if you're not in foreclosure. I want to put together a package to challenge your mortgage before you get in default. How's that sound? Yeah, and I already got, well, a really badass offer to pay letter that I put together because these people people don't realize that if they're demanding full payment, they have to provide you with that original wet ink document to prove to you that nobody else is gonna be trying to charge you shit after you get done paying them full amount of money. So my new strategy kind of set up to back to for you to offer them to make full payment and let them know you want to pay off as soon as they can provide you uh, with the documentation that they need to provide you with to make it legal, and then you're going to show them the statute showing that they have to provide you with all of yeah. So and it's all I'm still kind of working on it, but I'm going to need a few people who who are not behind and who would be interested in investing a little bit of money in this program to see how this works for you. And for the people, if there's anybody interested in it, then that person I would be working with that person pretty close, because I want to make sure that I can structure the package to get done what the goals are that we need to get done. So, and this is kind of a whole new thing that I'm but here's the deal, man. If you don't step up and go for it, you're gonna end up with shit for the program when the fat lady get done singing. So, well, yeah, okay. Anyway, when somebody get done singing. So if there's anybody interested in that, just send me an email to my business email address, winningcourse1@gmail.com, and just put guinea pig in the in the subject title. Just put guinea pig, and then I'll know that that's for that, and I'll save that into a file so that I'd like to have about 4 or 5 people that would be interested in it. So what you're going to be doing is making like a $300 investment into this new program, and that investment will entitle you to everything that I need to put together for that problem. So you would be like the first ones to use it, and you would help me figure out what documents I need to have in it to make them straighten the hell up, based off of how they respond to the letter. So, and I'm still kind of putting together. So yeah, but it's coming together, and I got a couple of the documents that the main documents that we need to use for it. So that's what I got going. So it's pretty cool if I can put together a package that people can use before they get. Hey, Frankie, 5 times. We got some new stuff, Frankie, since you purchased your package. So you should send me an email. So that's one of the new things that I'm working on. It would be pretty cool to be able to challenge this shit before you get in default. How cool would that be? Yeah, I think the attorney's pissed off the wrong person when they think and piss me off. So that's all I got to say on that. So Nikki, I know what California CP 10 or whatever that is, but that's not a valid law because that doesn't even look like a code. That's lower than a code. So, and a statute's not a valid law either. So you can cite all of that stuff that theirs that you want, but they're not valid laws. And this is the part that you're missing. And until you catch this, you're going to struggle because you use these things that you're posting to interfere with you going forward with the unknown. That's my coaching. So I know I've seen all of those. I don't use those. And when they try and stop me, see, a lot of times people will see that and they don't even understand that that's not a valid law or how to challenge it for not being a valid law. They see that and then they think they can't do it. Or they think they can't do it because the judge said no, or any of that. So those people don't fit well in my program. So that's all I got to say for that. So that is about all I have to share with you guys tonight. I appreciate the value of your time, and you guys should definitely get that $75 package that I put together for the stick in the judge's face because you don't have to wait. If the judge is signed on to your stuff, I would file that against him and just start your lawsuit right against them. Move that shit over into another court or take control of it and make them have to answer to you. After you file it against the judge, you can also recuse the judge and force him to go sit down because there's conflict. He got a problem now because there's a lot of power in the documents that you have, but you need to not pay attention to these statutes and these rules and these codes and shit and use the stuff that I got in the document in the package because I have a lot of people using them and I have wonderful reviews. And I don't spend a lot of time worrying about what codes people find and stuff because the people finding those codes aren't actually doing anything except worrying about the codes. So that's all I have tonight, you guys. We see you guys next Tuesday, I think.